Hello and welcome to this week's video blog on the law. Right or wrong, BC remains the most favourable province in all of Canada to people who wish to challenge the fairness of the last will and testament of another. In previous blogs, which can be found on our YouTube channel below, we described how BC law allows spouses and children of a deceased to challenge the will if the will does not make adequate, just, and equitable provision for the support and maintenance of them, even if that spouse or child is financially independent. Many people disagree with this law, saying a will maker should have sole and overriding discretion of what to do with their estate. But Canada's highest court has found BC's law to be fair. Indeed, if you'd been treated unfairly because of your sexual orientation, your gender identity, mental illness, or your choice of spouse, or some of the other reasons we see testators cut people out of their will, you might agree as well that the law is fair. There are, however, limits to the law's ability to change somebody's will. And last week, the BC Supreme Court clarified one of these limits. This clarification relates to whether a child that has been adopted out by a biological parent can challenge their biological parent's will. In this recent case, the executor of the will, that is, the person identified in the will as responsible for administering the wishes of the testator, that is, the person who wrote the will, applied to court for an order that a child of the testator who had been adopted by other parents did not have standing to challenge the will of their birth parent. The court noted that the BC Adoption Act provides that when an adoption order is made, the child becomes the child of the adoptive parent. The adoptive parent becomes the parent of the child, and the pre-adoptive parent is no longer a legal parent. This means the adopted child is no longer a child that can challenge their biological parent's will. This makes sense because in many adoptive situations, once the adoption occurs, or even before the adoption occurs, the adopted child maintains no contact at all with their biological parent. However, there are many cases where a child who is adopted out, particularly when adopted as an infant, reestablishes contact with their biological parent and goes on to have a full and sometimes financially dependent relationship with that biological parent. In those cases, this recent court decision would say the adopted child has no claim against the estate of their biological parent, no matter the degree of relationship or financial dependence. I hope you've learned something about the law from this blog. Feel free to like us on Facebook, follow us on Twitter, or subscribe to our YouTube channel. Thank you very much.